We're recording and we are off mute.
Mr. Palmer?
Okay, thank you very much. My name is Ian Palmer. My wife and Dieter Hood and I own a property on the Rangitoto Peninsula. Our submission, presentation today relates to our submission S249, and it concerns only the Rangitoto side of the Maunganui Rangitoto Peninsula Heritage Area B. In essence, our proposal relates to an objection that the Rangitoto side of the Heritage Area Part B is essentially too an extensive area on account, and originally we argue because the based on, as we say, the ill-conceived, unjustified, and in some ways contra virus, I'm not with the law. The relief we seek is, we're not saying it shouldn't be over any part of the Rangitoto Peninsula, but we're saying it should be confined to areas proximal to listed heritage items, and the key colonial built heritage item is the Butler House and Trading Station former. And also we say if you like, it could also encompass sites of significance to Maori, and we suggest there are two sites of significance of Maori that aren't currently scheduled, which could be scheduled, they being the two paths that face the harbour, Rangitoto Pa and Morihori Pa. So the evidence you have from us is kind of two parts. The original arguments we put in our original submission, we argue weren't fully or weren't really addressed, we think, really at all in the Section 42A report. So that found a copy of evidence there that includes in back all of the attached documents to our original submission. At the front is our latest or our evidence in response to the Section 40, what is in the Section 42A report, and there we list a number of reasons responding to what's in the Section 42A report, which we argue supports our objection and hence our proposal. Now, obviously, I don't have time here to go through all the reasons or the arguments in our supporting our objection and proposal. So I'm really here today on the basis that hopefully you've had the opportunity to read our evidence and take it as read, and mainly here to respond to the panel's comments and questions. But just by way of a little background, I have a few slides. We don't need to go through all these things, what things you might want to focus on, but just to give you a little background, my involvement in this matter, not a Johnny come like this one, goes back to May 2021 when our local, Cheryl Bainbridge, our local rep on the community board, identified the proposal to put this heritage area over the large area of Maunganui Rangitoto Peninsula. She alerted the community, countless members of the community, she alerted the community. That led to Danny Sims, who's picture of the newspaper there to the right, organising a public meeting on the 4th of May 2021, 200 odd people who were upset about what was proposed. So you might say I'm the last man standing. There's 199 people aren't here today, although I would suggest that many of those 199 people aren't happy with what's still being proposed, and most of them, when you talk to them, have got no idea that what's proposed is still going on. They haven't heard anything about it for 3 years, so it's probably been dropped. But that's just the way the process runs. So our submission is supported by the Ferguson. Some of you might know the Ferguson family that owned 65 acres on the other side of Rangitoto, which includes the Butler House and the Waitangi Museum, and also I would say our submission is supported by the Nonganui, the Tihiku Community Board. I've spoken to Cheryl Bainbridge lately to, to be able to say, to make that comment. I think it's fair to say, Cheryl said she would like to be here, but she personal reasons she couldn't appear. But I think it's fair to say that she was not particularly happy that the way the process was run, particularly that after the community board made a submission opposing the extent of the heritage area, including Rangitua Peninsula, that they weren't consulted prior to the Section 42 report. The Heritage New Zealand, who wanted to expand the heritage area even more, were consulted greatly, but the community and the represented by the community board, and of course ourselves, were consulted in the lead up to Section 42A. You've seen this picture before. We go to that. It's the minor changes to area green, not really significant to this. So that's essentially, correct me if I'm wrong, John, but I think that's that area essentially goes back to the report that you finalised in June 2020, gone through the draft of the proposed plan and feedback on that, which largely opposed it, gone through the notified district plan objections at that stage, and now we're to hearing. But just to have a little look at that in a slightly different way, with you see Maunganui down the left bottom left-hand corner and the Rangitua Peninsula there. So I put on some of the other relevant, what I think are relevant other overlays, and one thing I'd point out in terms of sites and areas dealing with the Māori, you see quite a few in the area, but as it happens, none on the Rangitua Peninsula, albeit we are recommending you add a couple on the two paths we spoke about before. But focusing in a bit more on the actual area we're concerned about, the Rangitua Peninsula in the top right. Just like to point out that in addition to the heritage overlay, there are a number of other overlays that go over all of the land in question, certainly the coastal environment overlay, and also significant parts of the outstanding natural landscape. And you may recall, we made a submission on that as well, arguing that that too was somewhat too expansive. But the point I make here, on the basis that that is what's currently in the plan as we're responding to, notably that outstanding landscape area doesn't encompass the whole of the Rangitua Peninsula. And one of our arguments you will have seen in our evidence is that in effect, the extending the heritage area over a much larger area, in effect you're trying to protect landscape under the guise of heritage, which the Environment Court has ruled you're not allowed to do. So just in terms of our particular property, we own 3 sites on the front, partly on the harbour and partly on the northern the Douglas Bay coast there. The site cut up by some paved roads. On the top left-hand corner, you've got the Rangitua Reserve and Pass site, and as some of you may know, myself and my whānau have been probably the leading parties campaigning for the better katiaki of that site in conjunction with our local Apu Ngāti Ruawiti. Ironically, as I said in our submissions, that's the area of the whole peninsula that's the worst kept, the worst protected, and that happens to be what the area that Maunganui Council has stewardship over. But to be fair, finally that agreed to the management plan for that site, which pushed for that for the last 8 years. Just focusing more in detail on our property, some time ago, subsequent to our original submission, we finalised some boundary changes, which is 3 subdivisions, but we started with 3 sites, we ended 3 sites, but it's still called a subdivision. Anyway, as part of that, we agreed to covenant certain of our land, and that's shown the dark shaded green areas, and while there are conservation covenants, and that gives us a tiny amount of rates relief, as it happens, a lot of the what I call the minor archaeological sites are also in those covenant areas, so they have that as a sort of degree of protection because they are we have voluntarily covenanted them.
So can I just interrupt for a second? It's only because I can't read the fine print on this plan here.
Yeah.
Oh, this one.
Yeah.
Can you just explain what the yellow, red and blue?
They're just our 3 sites.
Those all 3 properties are yours?
Those 3 sites belong to my wife and my sister.
I say, so you used yellow to highlight lot 3 and 4, red to highlight 1 and 2, and blue to highlight 5 and 6.
Yes, because we were talking over lunch, because of the existence of the paper road, Lynn's insists that the titles are comprised of multiple lots, but we only own 3 titles, which are also 3 sites, which also happen to be 3 rating units, but we happen to have a number of lots because we've got the paper roads.
No, so I understand what the paper roads do. I just wanted to understand what the colours mean, but they're basically just like identifying your the 3 land ownership areas.
That's right, and to the bottom right is area that's largely owned by our neighbours Ferguson's, but there are 3 other smaller properties on the peninsula in addition to ourselves and the Fergusons. Between the Fergusons and ourselves, we own 86% of the land area of what we're talking about here. So that's just the next one, just a little recent photograph of largely our properties. Also see the Maori Pa, the Rangitoto Pa on there on the left as well, the recent clearing vegetation by the council. So our property, other than the coveted native bush areas, we run it as a little hobby farm with 8 cows and a couple of chickens and sheep and whatnot. That just gives a bit of impression. One, just before I forget, the presentation by the Potorua group, which I definitely support everything they said, but except one thing wasn't quite right. The Waitangi Peninsula is an area, I think it's fair to say, where there's been a combining of European, colonial European built heritage, which got the house, etc., on the southern side of the peninsula, with our area, which doesn't have any colonial heritage values or features, as far as we know, but is presumably, and this is not made explicit, but presumably included in the heritage area because of its pre-European Maori archaeological aspect. So, we believe there's some of the same issues that arise when you combine an area where you're trying to look after Maori values and colonial built heritage values all together, and we're sort of in the middle. So, if we want to build something, are we meant to sort of honour the Maori sensibilities on one side, or are we meant to honour the colonial built heritage values? And the other point I'll just make there, in terms of, in the sense we're running a little hobby farm, the rules as they are, if, I've just done some recent minor fencing, every 10 fence posts I put in was dug to deeper than 500 millimeters. So, if I'm going to, put in a fence post or, dig a culvert under a road or bury a cow, rather, I've got to apply for a resource consent arrangements. And I guess, and also, just on that, the concession which the Minister has proposed to make a permitted pathway for building, houses, sheds, I suggest that that's a little bit disingenuous is too strong word. But typically, if you apply, if I did a couple of years ago to build a structure that you might get a shed, which you see there, typically when you apply for resource consent to build something like that, it's associated with other things, in particular earthworks. And, you know, there I have a shed on virtually almost flat land, but even there I was required, you know, practically to do earthworks greater than 500 millimetres. So my whole consent application, including building a shed, was classed as not permitted, as restricted discretionary company member because of that. And it's the same, you know, certainly building a house. I mean, you know, you talk to civil engineer, there's not much you can build with, you know, a house even on flat land without digging more than, you know, 500 millimetres. And the other point I make with that it was, you know, a lot of emphasis was given, Minister emphasised in the report, which was strictly true, that the requirements then to consult with Heritage New Zealand, Tangata Whenua, etc., is not a legal requirement, but that's exactly what happened with my shed application, which is, I think, typical, is the, and I asked this question to the council planners, but I emailed back a few months back clarifying that while it might not be a legal requirement, I was told it's highly likely that the planners, the resource consent application, will stop the process and ask for additional information, including such things as a cultural impact assessment, archaeological site studies, Heritage New Zealand, and so on and so forth. And you're quite right, I can legally say, you know, like that, I'm not going to give it to you, but that automatically triggers my consent application becoming notified. And you can just imagine if the planner said, I need this additional information to make good on my authority I have, my discretionary authority to treat your resources, and I said, I'm not going to give you that information you say you needed, that sure, it might be not legally required, but in practical terms, I'm required to give it. So it's a bit disingenuous, I think, to say, you know, there's a permitted pathway for building things, given that for those two reasons. Anyway, to move on. The one thing I guess we have a problem with is what it all comes down to. What's the appropriate area for this heritage area? We don't object to having some heritage area on the peninsula, but the consultants done 2020 report. It was titled the Rapid Assessment Report. So it's called, which I think that title is good by itself. But anyway, the Rapid Assessment Report noted there was 3 key sites, pre-European key sites on the peninsula, and you can see them there. The Rangitoto Pa, which certainly is a significant site, and Moihuri Pa, also on the harbour there. You've got the Butler House and Training Station, which is a listed, category 1 listed heritage item. Then you've got the Phantom, what I call Phantom Pa. That part doesn't exist, and there's a recent archaeological review of the peninsula, which I refer to in our evidence, which where the archaeologists have confirmed that part doesn't exist, but it kind of looks very much like that northeast boundary of the heritage area has been, at least in part, defined by that part when it exists. The other thing that the Section 32 report commented on implied that area, the spatial extent of the planned heritage map area includes all relevant sites. Well, okay, there is a number of sites there other than those key sites, but most of those are you might call minor sites, disturbed middens, terraces, which are ubiquitous to the region. But if you look at the next slide, those sort of sites are, you know, here, there, and everywhere in this area. On the left, the arch site mapping of archaeological sites in and around, and then on the right, a particular study by James Robinson in 1997, and included in that report, you'll see he identified 31, he called them Pa villages on that Waitangi area to the north, and so I think it's fair to say that the heritage area boundaries are captured all the relevant sites in this area. That, you know, so what's the basis of being the boundary where it was? And to the extent, Heritage New Zealand, which is the only party that argued in favour of this heritage area, in effect, they argued that boundary wasn't appropriate as well. They wanted to have a much wider area, so in that sense, they're agreeing with us that there isn't a logical basis for putting the boundary where it was. Although I see Heritage New Zealand in their latest evidence, they don't mention Rangitoto Peninsula at all. So you might ask them tomorrow, but they do talk about Ororua, and I know talking to Bill Edwards and James Robinson, that I think they would tell you that they consider there would have been much greater justification for putting a heritage area on the Ororua Valley rather than Rangitoto Peninsula. So, moving on, another thing, there's a number of, if you like, shortcomings we identified in the Same Heritage 2020 report. I actually wrote to John and Adina Brown in September 2021, querying or was suggesting there are errors, there are things that misleading statements and things that weren't said that were somewhat misleading, and invited them to amend their report accordingly. I never got a reply to that communication. Anyway, what did get from that report did get actually into the PDP with that description of our peninsula, which, as I said, there is quite a distortion of reality. There was no, the Rangitoto Peninsula wasn't heavily involved in timber trade or the flax trade. There's sealing involved in it. And I don't think there's many whaling ships came here in the late 17th century. But if you see at the back of our original submission, you'll see that letter to Plan Heritage from 2021, identifying 17 concerns we had with that report. Moving one example, by way of example, that report devoted a page to the Deedsland C3, and it was said that showed Butler's house and trading station, house fields laid out, and sorry to use the pejorative term, John, but that was utter rubbish. It doesn't do anything like that. It's actually not Butler, it's nothing to do with Butler. It's his neighbour's 54 subdivision plan, some more cadastral documents at the end of my presentation here to give some evidence for that. So that's just an example. I think we think that the work that was done leading up to that 2020 report wasn't sufficiently robust. But then, as I said on the next slide, to be fair to John, he did caveat their reports heavily, and there's a lot more than these statements here, but essentially he was saying that the work that was in those reports was very much of a preliminary, high-level nature, and more in-depth work needed to be done, and also some particular things needed to be done, including defining sub-areas, which I took to be, which were where there was particular values, maybe colonial heritage values in one sub-area, Maori cultural values in another sub-area, and each of those sub-areas were to have design guidance and heritage management plans, and as he pointed out, that would be important because making discretionary decisions, the assessment criteria to be used was important, but none of that work, for reasons which I haven't established, the Department of District Council refused to undertake any of that further work, rejected all those key recommendations of the consultant, but nevertheless now rely on the same consultant to defend everything from the plan. Moving on, and this is sort of legal technical one, so I won't get into details of it, but one of the issues we have is that it's apparent that the real justification for the reason that we want, the council seem to want to put this heritage area over our cow paddocks, as it were, is to preserve the heritage landscape and including our open pastoral landscapes over our cow paddocks. And that's pretty well precisely what the High Court said you're not allowed to do. You can't, under the guise of heritage, you can't try and protect landscape. Sure, you protect landscape, you have to do it in the landscape chapter, and you have done that to some extent but only to the extent of your outstanding landscape areas. You can't sort of under the guise of heritage sort of extend that over much more countryside. The High Court and Grant Court refers to that as double counting, you're not meant to be able to do it. Anyway, I've got some backup slides which I won't go through, but that's, but I'm sure that the raft of, if you like, justifications for what we're proposing, and I'm sure John and Melissa will find fault in some of them, but I ask you to consider our justifications as a whole, and not relying on one particular argument. We think there's a wealth of arguments in support of what we're proposing, which, as I say, is to sure have a heritage area on the Rangiora Peninsula, but associated with sites of significance to Maori and listable heritage items.
Okay, well, no, thank you very much again. Another very thorough presentation. Thank you very much for that. It's pretty clear where I think you are coming from and what you want us to focus on. I think it will help council officers in their further evaluations. This is one of the benefits of having a hearing. You can come along and bring focused evidence on a particular area and help fill up the information gap. So thank you very much for that. I'll just see if the other panel members have any further questions.
Thank you. My question is, where would you draw the line? If you had to draw a line, or have you not really gone?
Well, I can be specific if you want, but we said in words conceptually, we draw it around the listed heritage resources, which, and one detail which is really on the Ferguson side of the peninsula, not ours, but that contributes to what I've presented to you today, so they would support this. If you read the actual listing, they don't list just the Butler House. The listing defines 3 titles. They own 6 titles. So they've got 3 titles that are listed, and in their view, that's very securely protected that land, and that's the little blue outline I've drawn on one of the slides there. So I think in your, I forget the terminology in the national planning standards, but there is a way to define not just a dot on the map, but an area, a heritage item area, sort of special term, I can't remember what it was. And if you read their original submission, they were in support of the heritage area covering at least those 3 titles. In fact, if you read their submission, they were even offering to cover a bit more land, including something around the Moihori Pa, which is on an additional one of their sites. And on the outside of the peninsula, obviously the key site of significance to Maori is the Rangitoto Pa. The Rangitoto Pa is surrounded by land that's the Rangitoto Historic Reserve. But the Pa and the reserve are not one and the same. The Pa is a fraction of the reserve. So there's already a margin of around the Pa. So we wouldn't have a problem with the whole Rangitoto Historic Reserve, which is along 71 parish from Mongu being within a heritage area. And we wouldn't have a problem with the heritage area covering the land that we have covenanted, which, as I said before, covers most of the minor archaeological sites as well.
Yeah, I understand that. Thank you for bringing that into words, and maybe someone could put that on the map. I just noticed that your neighbours, the Fergusons, in the reporting recommendations before us, have got some sort of exclusion areas. You probably can't see that map there, but it's in the 42A report.
Exclusion areas, what does that mean?
Well, it looks like they've removed heritage area from particular parts of their property. I mean, could the same sort of principle apply to your properties?
Well, I think I shouldn't speak on their behalf, but they've got 6 titles, and the largest of the 6 is the area which they argue in their submissions should be covered by the heritage area. They've already protected 3 of the other 5, and they've offered to protect at least some of the 2, but they want the one site, which is further away from harbour, not to be covered by heritage area because it doesn't, in their view, it doesn't justify that. So I have to look exactly what you're looking at to see whether that's the same thing. But in our case, I mean, essentially, it's what I describe as our cow paddocks. We'd rather than not have our cow paddocks the heritage area because I can't put a fence pole in without getting resource consent.
Yes.
And I know not legally requirement. I know from experience that will entail consultation with Tangata Whenua, which is actually the wrong term, should be Whenua. And in my case, there's at least 3 harbour iwi that all claim mana whenua status on my land. So that involves sort of talking to 3 different groups that don't talk to each other. So it's not appropriate.
Thank you. That's answered the question.
Kia tino marama, so you're wanting the rangitoto pā and moihuri pā separated from any heritage overlay?
No, we're saying that the heritage overlay, if you want, the rangitoto pā and the moihuri pā, we think, and the Fergusons think, deserve being, what's the word, notified as sites of significance tomorrow. In addition to that, if you want to, we have no problem with you putting the heritage area over those sites and maybe a little margin beyond them, but not further than that. And there's also, I mentioned in my evidence, I didn't bring it up here, that a 1950s Edmund stone cottage also on the harbour side, which I would have thought is deserving consideration being a heritage item, which is not really mentioned in the Exchange Heritage Report. So a much more limited extent of the heritage area, which covers and maybe with a little bit of margin the actual heritage resources or heritage items, as you call them in the plan, and the site that's in tomorrow. Now, you could argue, well, those things are already protected by other mechanisms anyway, but we have no objection to you, in addition, covering those areas with the heritage area, but we object to covering areas well beyond those significant sites.
I just want to play devil's advocate just a moment, and I'm going to try and praise the council's approach, and then probably get corrected. But what I understood about the Area B approach is that with the limited information that we have at the moment, it was likely that there's probably some archaeological resources at a depth of about 500 metres or possibly deeper, and that this was put in the ambulance. Well, this was not the ambulance. The ambulance at the bottom of the cliff is the accidental discovery protocol. You dig a hole and then you go, oh, that looks like there's something else there. It may end up being destroyed or compromised, but it's always a reactionary approach. I was saying on the preponderance of the evidence that we have at the moment, I'm looking at the nodding heads, which I've said I'm preceding it appropriately, that likely to be resource, and we need to tread carefully. And so there's that side of the equation, and do you agree with that approach in principle?
I agree that when you dig a hole, there's always a chance in this region that you'll uncover some evidence of pre-European activity. But that argument equally applies to a very, very large part of the region. And that's the point. And that's why Heritage New Zealand's submission was actually at least self-consistent. We didn't agree with other reasons, and the council didn't agree with other reasons. But at least they were self-consistent, saying, you want to define this little area as a heritage area. Well, actually, we can argue sensibly that a much, much larger area is exactly the same category. You dig a hole anywhere in that region, you're just as likely to uncover what you're talking about. Now, we argue, as you read our evidence, that as it happens in our little peninsula, there's actually been a very large amount of archaeological studies done for various reasons, partly because the Fergusons actually had an archaeological dig done on the Māori Huri Pa some years ago, and associated with that, there were detailed archaeological surveys done on the peninsula. So the chances that there's undiscovered sites on the Rangitoto Peninsula is probably less than the surrounding area that had less archaeological studies done.
You're saying I'm not opposed to the principle, it's just that why has it been applied to this land and not all the other land?
Yeah, and the 500mm thing again, for our land is farmland, not.
I'm just asking the question about I'll get to the 500mm question in a second, but I'm just looking at the principle of this, eminence at the bottom of the cliff as opposed to a cautionary approach when there is, in the opinion of council's experts, a likelihood of archaeological resources undiscovered.
Well, let's put it this way. For example, when I came to build my shed, under the current operative district plan, the council stopped the process and required me to have an archaeological.
I understand all that. I'm just
No, but this goes to your point. I was required to do an archaeological survey of that site. Now, the report didn't and couldn't identify any archaeology 500mm underground without digging 500mm underground. So it's only when you dig the hole are you ever going to find that. So and it is protected then under the Heritage Act and your accidental discovery protocol. So how can you protect something that you haven't found? I mean, the archaeology can be landform, dips and things, which they can infer that was an old hangi pit, an old kumara pit, for example. But they've already been identified. The ones you can't see, you're not going to find until you dig the hole.
Sure, but let's play that out a bit more. And as I say, I was playing devil's advocate. If you were subject to a resource consent and you were going to go deeper than 500 mils, the resource consent would probably have things in place like an archaeologist present so that they would determine that you might have found an archaeological resource rather than you or a contractor just digging a hole and stumbling across it as opposed to it being purposefully found.
Well, that's true, but that like a savoury fence post, I dig it'd be cold trap, but I need resources there.
And so, I mean, if we were minded to recommend to council that the overlay remain in place, but it be more forgiving, or if council officers were contemplating the same, what depth do you think could be more reasonable?
Well, it's actually going to be a question for me. I noticed earlier Melissa's presentation that Heritage New Zealand apparently pushing for a notification zone for Oro Valley. And I know talking to Jane Groms and Bill Edwards that early in this process they were very keen for the Oro Valley to have a heritage area open, but Heritage New Zealand weren't consulted before the draft, weren't shown the planned heritage report before the draft proposal came out, owing to misunderstanding, and the council thought they sent it, that Heritage New Zealand received it. Had they received it, they would have argued, and I think early on they were arguing for a heritage area over Oro Valley. Now they probably think it's too late to argue that because you have to start the process again and so forth. But and I don't really understand the full implications of that, but perhaps the notification area might be a compromise arrangement.
So the question I put to you was 500 millimeters isn't deep enough. Could you think, would you seek a deeper depth, or are you saying don't do it that way, just have a notification area? Is that your answer to my question?
Well, I mean, these would be better, but we have a number of arguments against why it's not appropriate in principle to have a heritage area here, including the mixing Maori and colonial heritage together. So that would be what you're suggesting, alluding to a step in the right direction, but wouldn't necessarily That's right.
I'm not asking you to abandon your belief. I was just putting a question to you, that if we were minded to recommend to the council that a deeper depth were more appropriate as a permitted activity, or council officers were contemplating the same, do you have an opinion as to whether, of what that depth might be?
I think you and I would have to consult a sewer engineer. I think, typically if you're building a house, even on flat land, typically how deep do you tend to dig? And just bear in mind, if you do a resource consent to build a house, like we've got 2 sites in our house bonds, so you could be in this position. Typically, you're not just building a house, you're doing earthworks, retaining walls, access drives, culverts, so on and so forth. Would a meter capture it? I don't, probably not. I don't really know the answer to that question. I mean, directionally, obviously that would be better. But it's a little bit how long's a piece of string.
Okay, no, I can't understand. You're not an expert in excavation. I thought maybe you might have had a view as to.
But certainly, I think, without,
deeper, but not sure how much deeper.
Yeah, but without being critical, I think, to be frank, 500 millimetres through on this sort of land is somewhat absurd. I don't think that Brian Cook is going to support that one.
Okay, well, thank you. I won't. Thank you very much for your answer. I'm going to put you on the spot there a wee bit, but thank you for your answer.
You put on the spot.
And your submission. Yeah. I don't think we've got any further questions. Sorry, just wait one moment. This might relate to you.
Yeah, look, obviously, for Ian, obviously Ian's here. So just to clarify our engagement with Heritage New Zealand, we went through and reviewed a number of submissions, particularly in relation to the rezoning topic, particularly looking for clarification on or certainty in the scope of their submissions. So while there were some matters, I guess, of Heritage spoken about, the engagement was largely about clarification of scope of rezoning. So just to clarify about why you're here, not specifically to collaborate on heritage matters.
Okay, I understand. Thank you. Thank you again, Mr. Palmer. Now we have Mr. Michael Hayes. Mr. Michael Hayes. Good afternoon, Mr. Hayes. Good afternoon. Please have a seat. Thank you, sir. Make yourself comfortable.
Sure, the Thunderdale Hayes and Sons Limited, family farm, S557.
Yes.
Now, in the stuff we get, we said it says that we've got to bring 10 copies of any information recording them. I've got them here. Do you really want to have them?
Alicia Kate will come through and get them from you, and just give her a moment to distribute them.
All right.
Very well. Well done. Thank you for making that effort.
And the things have changed in this big one.
One moment. We'll just wait until this gets distributed.
Okay.
And then we'll have it in front of us, and then. I like it. We've got tonight.
So we've got 4 documents in front of us that everyone should be in touch
Yeah, Mr. Hazelwood, we've got 4 documents from you,
Yeah.
and Educate's going to go and collate them with some of the other people, but I think we've got enough for you to start presenting the submission. They're in your hands.
Very good. Well, as I was going to say is that when I put the submission in, close to 3 years ago, things have changed considerably since that period. And I was involved with the first district plan and a lot of the issues with the sites of significance. We also were trying to put in a silent part for the Maori because a lot of the Maori do not like putting sites, urupas in for obvious reasons, because it's a traditional thing. And so, as I say, I was involved with the district plan, and so I was one of the first ones that got a sort of significance entered into the district council for the urupa. And what has happened is that at that time when we were talking about it, we didn't really understand who was going to actually formulate looking after it. I mean, actually developing it. And unfortunately, from the information I've given you, the district council has been a total failure. They haven't been able to process it, and we had the urupa that's recorded there has been bought by a developer, Ryhard, and he at the start he didn't have a resource consent notified. It was within a private one, and the district council and Heritage New Zealand should have actually held it up at that stage and made sure that the Roman Catholic Church and ourselves were actually brought into the whole process. That was not done. And you can see from the stuff there that we've tried to do things, and unfortunately, our sister wrote a letter to the mayor about what was happening there. We never got a reply. And so, for the sites of significance to be of any value, the district council has to have the ability to actually oversee it. And the problem is, as we know, their ability to look after the road is a wee bit lacking at present. To look after the sites of significance is just not going to happen. And if we, as I say, things have changed considerably since I wrote this submission. I've been involved in grazing land on Nuku's Aldridge property, you would know, Iwi Taroa's property. Now, in that period, at one stage, the councils and that tried to encourage people to bury their forebears in either the urupas that the Maori have themselves or in the public ones. But both these rangatira have had their bodies buried on their own land, which is fine. But the problem is that this is a trend that is happening, and if there's no way of keeping a record of it, there's going to be all sorts of problems, and we know there's a problem up at Ahipara with a cocoa tree, Pūtakau. And the problem is, if we try and get the Maori to, if they want to put their onto a list, someone's got to oversee it. And to actually oversee it would be a horrendous cost. And so when we were talking about that 3 years ago, when back earlier on with the district council, we didn't actually see what was going to happen. And so we've got a situation now. What on earth are you going to do with these lists of things that the district council is not taking this information? with the application for the, on the Urapa that we're involved with, that there is a archaeological report was sent to the district council when we applied to have it, and we had family members to actually write. That information was sent to the district council. What happened to it? It disappeared, because when the new developer bought the land, he got an archaeological report. And Heritage New Zealand, they should have followed it more than what they did, because they had that report that was sent to the district council earlier on. And unfortunately, both the district council and Heritage New Zealand have got problems, obviously, with trying to oversee all the things that are happening. And recently I've been involved with the Wharirā, Hongi Hickus Pa. We've been grazing it, leasing it for years. And what's the name, Davis, he bought it on behalf of the Crown. And we're still grazing it, and we will be looking after it as Kaiaki Aki. That is the only way you can actually look after this land. Because some people think that, oh, some of the locals, iwi will come and do things, but they don't. And I've been involved with the, there's a new river being put through our land in Kaio there, and they got to have archaeological reports. And this archaeological chap, he did a massive report on it. He didn't listen to us because we'd been grazing for 110 years and knew what had been done to the area. He didn't listen to that. He had to go through this whole list of things he was going to do at horrendous cost. Just pulling out forms for following the process that had to happen. And this is the situation we've got into now. That, I mean, he was looking for people that might have been buried there, and see the Boyd, the Boyd people were actually eaten not far away from where the river is. But instead of asking the local people, the local knowledge, they don't do that. And it costs New Zealand horrendous amounts. And as I say, we're sort of, I've been involved with Nuku Aldridge, what's the name, Taurau? Grazing their land, leasing their land, and the situation now has changed considerably because the younger people, both those older gentlemen, they were interested and very concerned about using the land, putting some use to it. But now the new generation, they don't want to work on a blooming farm. They don't want to. And so, and the whole thing is with the regional council has come in with the Y thing, and the fact that we've got areas of land, steep hill country and that, they don't want us to have cattle on it because of sedimentation loss and so forth, even though we've been doing it for years, and the hills are still there and that sort of thing. And this is another angle from the regional council. And unless that situation is changed, we've got the situation with the young ones on Taurau's block. They are concerned about the E. coli. They want to return it back to where you have pure water. But unfortunately, that a lot of them haven't lived long enough in the situation to realize that even if they stopped all the sheep and beef farming in New Zealand, you wouldn't cut the E. coli out because a lot of it is natural, a lot of it comes from the birds and everything else. And to think that you can actually stop us grazing it to make the water fresh and totally pure and natural is totally unrealistic. And so it goes further is that if this land is not being used, who's going to pay the district council the rates to actually do something about looking after these areas? Because it's not going to be there. A lot of the local people, I come from the Pupiki Valley, a lot of you probably know where that is. A lot of the people in that area basically aren't paying the rates anyway. Well, that doesn't matter. That's been going on for years. We've put up with it for years. But if the new generation that's coming on wants to do the same with all the land as it comes up, I mean, there's no way can they look after the sites of significance, the marriage sites and everything. And so this is part of really, it's what I'm trying to get at with my submission is that the situation that's been set up is not working. How are you going to make it work? I don't know. But those things that I've put in front of you, they're Urupas, they're all sorts of things, they're definite sites of things, but who's actually going to actually follow the thing through when someone buys a property? Who's going to tell them, well, hang on, you've got to actually contact this council first before you buy it to see if there's any sites of significance, if there's any sites of that the marriage have included on the property before they actually go in and start doing something. It's too late once they start doing the work for the district council to turn around and tell them, well, you can't do that. Because in our case, he's already done it. He's developed the whole thing. And it's as I say, it's if you have any questions on those things that I've sent out, I'm open to hearing from it, but that states the things as they are. And I think the new plan, they are more concentrating on the sites, heritage sites in the main areas, Russell and other areas, and that no mention about the rural areas like Whangaroa and that sort of thing, where there's a considerable amount of heritage, because that's where a lot of the early marriage was circulated. There's a paths there and everywhere. And so under the district plan that I think you're looking at, I did have a look at the things that happened in the district council office in the library in Kyo there, I mean in Kirikiri just recently, and looking through it, I think, oh dear. Oh dear. And so, yeah, that's my main submission, is that the system that's set up at present cannot work because they haven't got the revenue to actually have someone sitting in the Kaikouri office actually in charge of that completely. And so that when someone writes to the mayor, they actually get a reply. Because the thing with this is that the Catholic mission site there, as you see from that, they had there's a site there, a memorial site that that represents when the first mass was held in 1860. That, for instance, the developer, he shifted that memorial site. He shifted that further away, and that sort of thing. Unless someone is there that actually does something, developers will do that, unfortunately. And us local people are left to sort of, yeah. And as I say, we do our share a lot. As I say, we've got Wharewa, and we'll be looking after that. But it's unfortunately, and we've got the situation with the Kyo River there, that they want to dig a river there, another river, and the regional council is very keen to put in another wetland. And they're asking local people if they want to contribute to plant trees and everything, but we don't want them to plant trees, not in a floodplain. But anyway, the lady that is involved is encouraging locals to come forward to help plant the trees and look after that, but that's not going to happen. And this is what we're facing with the regional council at present, and that what they think will happen There's going to be changes to the laws with the regional council coming up in June, with the rivers and all that sort of thing. And so, unfortunately, you've got to have a mindset with the regional councils. You've got to have a mindset with the district council to understand what they need to be doing. But this all costs money.
Well, thank you very much, Mr. Hayes. If I were just to quickly try and summarise your submission, you support this site being recognised as a site of significance to Māori,
Yep.
but you've got concerns about whether it's actually being protected. And
Well, it wasn't protected
Yes.
because the new landowner came in and went ahead, regardless of the district council being involved, regardless of the historical society being involved.
Yes.
Instead of actually ensuring that we as part owners, an interested party and the Catholic Church, they were the ones that should have actually got us involved, but they didn't.
I understand that quite clearly. I'll just see if any of the other commissioners have any questions.
Are you saying that that site has been destroyed and it's no longer there?
There's a letter there from my sister to the mayor.
Yeah.
And she explains what had happened. There's a cross that was put up by the local Maoris from Waitangi, actually relations of the mayor and so forth and that sort of thing. They cut that cross down and chucked it down the hill. That cross was actually blessed by the local Maoris. And there's a big thing nowadays is that you bless things. But what's the point of that, suggesting you bless them, if it's totally ignored? Totally ignored.
Yeah.
And I would like to mention too that site, the site that Jacob Hakopa Adams actually had the stone carved, a solid stone carved and put there. There's very few symbols or monuments in the area put in totally by Maori. Very few. We've got a stone cairn in Tyre there where the first Wesleyan thing was put, that was put up by the Maori. But there's the Maoris have their own urupas and everything, and they look after that exceptionally well. But there's no actual historical monuments apart from this one in the whole of Longrock area.
Hi. Oh, tēnā koe, Matua. Lovely to hear your kōrero. Just a couple of things. I was just trying to find out who's the head Catholic in Taitokerau. I see online it's Bobby Newsom, but I don't know who's the head priest in Taitokerau. Do you know?
No, I don't.
I don't know.
No, they have one of the priests comes from Kirikiri.
Oh, yeah.
Yeah.
Okay.
No, the Waitangi has reduced. They still got the school there and that sort of thing.
Yeah. Yeah. Just.
But Moana Woods she's one of the ones there.
Who?
Moana Woods. Harry Brown, but he passed away.
It's a big taki, and I think I know of 3 churches in Te Raroa that are sort of Catholic churches that is trying to work together because they're coming up for 100 years, 150 years,
Yeah.
etc. So, Aloha, not really sure what to say, but I just really, I suppose I was going to ask, do you have anything to do with Te Runango Whaingaroa?
Well, yeah, we know some of the people in it, and they're Runanga, yeah, because they've been involved with the river that, they don't want to be involved with now. Yeah, and see, the Cowraws are involved with the Runanga.
Who is?
Cowraws.
Oh, totally.
That's,
Hiwi's Mokopuna.
Yeah, Robin and that. But see, that's where the situation where the younger, they want to change they basically want the Puketi forest and all that sort of thing is to return to the Maori, and it's tapu. But whether that's realistic in our modern age, I don't know. But that, and as I say, a lot of them don't want to work on the land. And they don't necessarily want to do anything to make the sites better or look after the sites.
So, Mr. and Mrs. Reinhardt bought the property. Mr. and Mrs. Reinhardt bought the property.
Yeah,
With the urupa.
yeah.
Do Māori still bury there? Do they still take their...
No, but the site was Moana Woods, who's the one of the key ones, and Isaac, who provided the land. They identified the urupa back in the earlier district council things. That's the one before that came into the one that's operative now. She was the one that actually had it put into as an urupa.
So I'm trying to understand, because we're having problems with urupa, you want from the council, you wanting from the council or from the iwi or from the Raiha whānau, some sort of commitment to look after that urupa?
No, it's too late.
Yeah.
Too late. What we're wanting at the time was actually to get some access to the urupa.
Access.
And that, it was a part of the original title that they had access from the water up to the urupa. From the thing there up to the urupa. But in those sort of situations, times have changed, and if there was no suitable site from the water, provision should have been made from the road. And he has sort of got some access to it in that, but the problem is that the urupa, the site, he knows how to manipulate things, and he's putting signs up for a lot of the Maori sites on the peninsula and that sort of thing. But all these things are fine, but they mean nothing if you can't walk down to it. And he's giving the point QE2 situation. But that, unfortunately, QE2, whether he uses it or not, I don't know, but you don't have to pay rates on QE2. And the other thing is, if you've got a QE2, there's no right of access to that QE2. So these are the things that needed to be looked at when he first bought the property and went into it. And that's where the district council, with the lack of the resource consent being made public. And so what we're trying to do now is, the work has been done. We've still got to go back to Raiha and try and work out something with the access. But the problem is that because it's an urupa up on a hill, the access to, generally it's old people that want to go to it. And it's no good having a walk from here to the other end of the thing here. It's got to have basically road access. But whatever happens, I don't know at this stage. That's in the future. But he is meant to be maintaining the around where the urupa was. We used to mow it and that sort of thing. He's meant to be doing that, but whether he is or not, I don't know. But these are all the aspects of setting things up, setting a site up. Who looks after it afterwards?
Michael has got an ancestor buried here.
Sorry? Who?
John Hayes.
Yeah, no, my great-great-grandfather's buried. It's in the information you got there. Yeah.
And also also that Pompeia came there and got a sight of whose place we reached there. And also Dave Porter's bones, backgrounds in Kyle.
But no, there's a couple of not priests, the next one down, were actually buried on this site as well, yeah. And there's a number of people that were buried. My wife there is doing a thing on it, trying to find out all the people that were buried there. And this is what happens. So the developer, when he got there, he used the modern technology, shades the things down and looks at them, and he said there's only 2 people buried there. But we know that there's close to 30. And this is a problem if they don't use local knowledge, you can totally lose the plot.
I'm just wondering, would anybody in council know, because this is access to an Urupa, a Māori site of significance, how can, is there a process for people to access the Urupa? Because I know of a couple of situations where it's similar, where, you've got a Māori Urupa in the middle of somebody's farm, and it becomes problematic getting access when they want to visit. And, some people have all kinds of protocols, for you to go and visit. But I don't know from the council.
Yeah. No, I think we've lived in the area for many, many years, and it's common knowledge that if there's an Urupa there, you've really got to acknowledge the fact that people involved with it have the right to walk into it, as long as it's practical access.
Okay, no, thank you. I would like to hear from the council. It's an excellent question.
That is an excellent question, and it's like a lot of subject matter around sites of significance in Māori land, complex, which is part of the problem. In my experience, working with other local authorities, there is no blunt tool that we can put in there, any words that we could put in a plan that would necessarily obligate on any and all occasion access, recognise that that's a critical issue for cultural and spiritual relationships with those sites. I don't think the district plan is set up to do that. In saying that, there are opportunities through the resource management process potentially to negotiate and discuss individual agreements on a case-by-case manner to be able to gain access to those significant sites. But it's not like everything, it's not a straight line, and it's a very, very challenging process. It needs, to a certain extent, a willing landowner, but not always. But I think it's best done between willing landowner, willing participant in those processes. There may be exceptions, for example, where there might be, for example, a subdivision that's required to provide riparian access under the law, which might also have sites of significance on it. So there'd be, through a subdivision process, you could consider perhaps whether access either through the general public or privately might be appropriate through that. But generally, it's largely through the subdivision process and wouldn't often occur as a statutory or rule-based kind of provision on a land use basis, in my personal experience on it. But certainly I would recommend relationships as probably the best way to manage that situation for enduring and ongoing access to sites. But acknowledge it's a massive issue.
So obviously relationships with the landowner and perhaps shared agreements in place that go into perpetuity, access and covenant or something like that, or at least signed between a number of parties. Example, are they sort of
those are examples? Yes, absolutely. As I say, and it's very much horses for courses thing. There's so many individual circumstances around where the site is, what the sort of site is, how often people might want to visit or be present on the site, what sort of whether they're going to occupy the site for a portion of time. There's so many variables that potentially involved in it, but it can be successfully negotiated, and there's opportunities, I think, through engagement, through statutory engagement, to have those matters discussed. But again, I'll recommend that it's probably best dealt with on a relationship.
Yeah, and if you had direct access, say, from the sea, it would still require those resources to be within like an SPNL reserve.
Yes, no strip offs or to get access down to
It's one thing to get to the land, but you still need to get over private property to access.
That's the issue. Yeah, and I understand there's quite a few landlocked sites of significance that are accessed on coastal, just only coastal access. And it can be problematic across the board for everybody who might want to visit the site because it's not to get them.
Okay.
Well, I just suppose I want to acknowledge that you've been doing this for over 25 years. And mahi kia koe, me tō whānau. And I know of several situations that are similar to yours. And even sometimes people with access still can't get to. So I don't know how to really assist you in that, but there is a hui at Cockthorne at the moment with a whole bunch of Catholic priests. So if you wanted to drop in and see, I don't know who the leader of Taitoketo is, but you know, I think it's something that we need to work with, not just the council, because I think there were some sort of statutory interventions to allow people, but they did have to have rules like you had to get permission from the landowner, it was only for a certain time. Same thing, old people who couldn't walk, and so they started to ask, could we have, you know, four-wheel drive or something to take them to that to that point. And but it took a long time to negotiate that. But you know, I just feel so low. So drop in on the Catholics down at the Cockthorne.
No, well, I mean, the Catholics were involved in this, the Waitangi, they were involved with this whole process. And so they didn't actually, they tried to do something, but it didn't work. And basically, as far as being involved locally for many years, that the access is something that needs to, when there's a land sale, that is when there needs to be a discussion on the access problem. And that's the time, and that's why when there's a land sale, it's important that the district council ensures that resource consent is open to the public, and so that they know that a piece of land has been sold, and or that they, smaller titles, there's been a lot of land sales in our area recently, and somewhere they should, and the land agents should be required to actually contact the district council to see if there's any sites, and we've had sites in our local area sold just recently, but unfortunately the district council, their records and properties have sold without with paper road access and this sort of thing. Now it shouldn't have happened because their problem is fairly massive. But the key thing is that the start, if land has been sold, is that the district council advises the land agent or whoever that site, we had land sold recently next to Parirawa and that sort of thing. And when Parirawa was sold, for instance, a number of years ago, the land agent didn't know that it was Parirawa. And this is where these lists come into fruition, is but then the problem is to get the people to actually look at them and have someone to actually have them in order. So whether you're able to do something there, that'll be fine.
Just a quick question. So as this particular site is scheduled on council's Māori sites and areas of significance as an EPA, with descendants of J.D. Hayes.
Yeah.
Just a query, how did the EPA get established? Were you the landowners at one point in time, or?
How do you mean?
So where the site is now, was that your land at the time?
No. What happened was John Hayes, my great-great-grandfather, he was an agent of the Catholic Church. Okay, and so he became involved very early on with it, and as I say, then he was buried. Yeah. Whereas that's not like all families, the rest of the family have all gone Methodism.
No thanks to the Catholics.
But they're still the great-great-grandfather, yeah.
Thank you, Mr. Hayman. Don't go just yet. I think got a question of clarification from one of our officers through.
Just wanted to add for the panel's information and a number of things. I think what this Mr. Hayes submission highlights, and he submitted in support of the retention of this particular site, so no-brainer. Yes, we accepted his submission. What he's highlighting is different things related to that submission. The issue of access, the issue of how council provides information in respect to on the reports in respect to when land is sold. And but I think the particular thing I want to highlight at this point, and we did highlight it in our Section 32A report in respect to this chapter, we have not reviewed Schedule 3, the sites and areas of significance to Māori fully. And what the site MSO 620 that Mr. Hayes is submitting on highlights for us that site has come from a legacy plan. So the sites that in Schedule 3 and the PDP have all come from our earlier plans. So we haven't done any review of those at all, and there are issues coming up all the time in relation to its accuracy and its history and background to some of these sites. And that piece of work, it's a big piece of work to review Schedule 3 in this district and also to add and remove sites. So just want to acknowledge to the panel that work hasn't been done. We highlighted it in the Section 32. We haven't got the resource. Of course, that's an issue for our governance as to how we resource that big and important piece of work, because as we can see from all the submissions we've had today, we're talking about, a district that's full of, cultural and historic things that are important to Māori. In fact, you could venture to say that, the whole of the Māori district is more for landscape. That's kind of, that's not subject of this particular comment. I just wanted to highlight.
Thanks, Councillor. We are mindful that this is in principle supporting the scheduling. But having said that, this is highlighted a number of issues that go to implementation and enforcement. And whilst it's not necessarily strictly within our wheelhouse to make any of those recommendations, I still think it's helpful to get that sort of feedback about implementation and practicalities of these resources, and also to acknowledge council's limitations with resourcing. It's all very relevant and helps. It's helpful for our job. Do you have something to add to this?
Just to note that we continue as much as we can. We haven't reviewed the fundamental content of the schedule itself. We do try, we have been putting effort into making sure that it works better or more clearly to avoid situations like what's been described occurring. Look, we are, for our own interest, looking into the specific situation so we can understand all the details that apply. That might not be necessarily something that is useful to the panel, but for our own interest, we're going to look into that to make sure potentially where the issue is. But we continue to have a look at the approaches that we've got in the group of.
If perhaps down the line this may still resonate, this evidence may still resonate and be on the record to help you in the future when you come around to looking at that detail. Well, thank you again, Mr. Hayes.
Can I just ask a question of the lady here?
Questions come through me.
Come through you, okay, boss.
You can just call me.
Where does has the district council got a specific person in their hierarchy that deals with these situations? with the SNAs, sites of significance and those sort of things, so they don't get lost in.
That's a very good question. That's I think there's any number of council officers who could answer
Yeah,
that question.
exactly. Yeah, look, obviously it depends on what process we're going down. It could be the consenting manager is responsible for resource consents. It could be the compliance manager if it's a compliance issue. Ultimately, the chief executive is responsible across all matters. And for this process, it's myself and Tammy are responsible. So,
Tammy, could you just put your hand up and identify yourself to Mr. Hayes? There's Tammy there.
That was a great answer.
I think Mr. Hayes wants to know, who do I contact?
yeah, so I guess for consenting matters, the consents where things have happened that there is no resource consent, it's the compliance team, the compliance manager. And as I say, for this process, for listings in the plan, it is myself and Tammy.
Right.
A bit confusing, but you'll find somebody, I'm sure.
Okay, well, thanks again for.
Well, just one last question. I see from the information that's been sent out for the hearings that there's quite a few numbers of sites of significance entered in there who marry, and no doubt there'll be a lot general public and that sort of thing. How are you in a situation where you can deal with them now?
Well, we're going to be hearing some more evidence tomorrow on those things, and we've got some EV representatives giving evidence tomorrow. So,
Very good then, sir.
well, thank you very much, Mr. Hayes. I think you've raised some really important issues, and it's been heard, very clearly by us and also by the council officers. And thank you very much for raising this issue and for the efforts you do to protecting those valuable resources. Thank you very much.
Thank you, sir. Thank you.
Now, we are moving on to Top Energy Limited. I see Ms. McGrath, you've got you and your team there. We're very much looking forward to hearing from you, but I think we need to have just a little 10-minute break. So you can perhaps set yourself up there. I understand you were going to, you've got yourself, Ms. Collins. And is an electrical engineer going to be here?
I understand, so I'll try calling.
Oh, he's online. Is he going to be online? Okay, well, you've got 10 minutes to sort of try and re-establish that link.
Thank you.
And by all means, make yourself comfortable
You've
enough.
got time. You've got time.
It's 3:32. We'll make it 1:45 and we'll recommence.
Okay, muting the room.
Or so.
Yeah.
Who will be missing? Teresa?
Oh, she's there.
Oh, she's here.
Teresa?
But we'll reconvene now and hand over to Top Energy and Mr. McGrath. As I said before, we've read your evidence. It's really helpful. It's extensive and quite detailed. But I assume you're going to do one of the PowerPoint presentations to summarise a little bit. So we're in your hands.
Thank you. Kia ora koutou. My name is Liz McGrath, and as you've probably heard, I've been here before. First time here for Top Energy. My colleague, Mr. David Adam, has decided to swan off to Japan for a well-deserved holiday. So you'll see that it's a joint submission of evidence, but I'm here fronting it this afternoon. We have online members from Top Energy. I'll let them introduce themselves this afternoon.
Sure.
Hi, my name is Taryn Collins. I'm the property advisor, so I'm here to answer any corporate questions or anything in relation to our processes involved with dealing with historical sites.
Hi, good day. My name is Nishan. I'm here from Top Energy as well, engineering and planning manager, and will contribute on the technical side.
Okay, now you're all listed on our list here, so we have your names. Welcome. We're handing it over now to Mr. McGrath to run the presentation, so feel free to bring them in whenever you want to do.
Go away.
I'm going to search here for the
So just a brief summary of the key points that this presentation and the summary of the planning evidence will run through, which is just an overview of the network in the far north, the points of relief sought with respect to the heritage area overlay, historic heritage sites and areas of significance to Māori, and notable trees. So we touch on each of the major topics that you'll be dealing with in this hearing. So I'm sure most of you have seen this summary before. So we'll just quickly touch on that it covers a large area of the far north, serves 32,000 customers,